Should we proceed? So the problem here is that you have to stay in India for some time. How long is the question? So follow this carefully. What's the date today? 24 to 26. In the last 1 year, this is 12 months, you should have been continuously staying in India. Continuous stay in India. If you want to apply, this is a date of application. And before that, 20, this is 25, 2011. In the previous 14 years, any 11 years, you have to stay in India. Okay? Only then are you eligible to apply for Indian citizenship. In total, how many years? 12. 11 plus 1, 12 years. After staying for 12 years, you have proved your worth, that you can survive. Then you apply for citizenship. This is the extra condition for naturalization. Again, a reminder that this is meant for foreigners only, not for Indians. Clear? But just to also, okay, draw this quickly. Just rough draft. Don't color it, shade it. I mean, you can color shade in your house. So my point is, I hope you understand that the world is not fair. Okay, there is nothing called fairness and justice. It's a myth. It's a mythical concept. To give you an example, we have all this drama for normal people. If you are somebody who has contributed immensely in the field of art, literature, science, humanity, world peace, etc., then all the criteria can be removed by Government of India. If today Elon Musk wants to apply for citizenship, he need not stay for 12 years. He can be given the citizenship immediately. Clear? Right below this, criteria may be modified by who? Government of India. Government, not even the parliament. So please contribute to, so if Ronaldo, that's how it is. Ronaldo went to which country? Saudi Arabia. So much of drama in Saudi Arabia. Women cannot move out without male companion. He is living there in a live-in relationship. Nobody has a problem. Even God was succumbing to the pressure of rich and elite people. That's the beauty of elite people. Right? Epstein files. Who is going to jail? Nobody. When the moment you realize that the people who are ruling us are the worst of the humanity, you will be happy about yourself. We are fighting on trivial issues of caste and religion, and we are feeling guilty about it. Worst of people are actually governing us globally, everywhere. Okay, committing the worst of crimes on a daily basis. We should never feel guilty about who we are. We are perfectly fine. We're better than them, at least. Anyway, enough of motivation. Let's focus now. So criteria may be modified by Government of India. The last one is incorporation of territory. Meaning what? If we take over some territory. Today, if we attack Pakistan and capture Pakistan, Pakistani people may become Indian citizens. May. If you incorporate a territory, the people there can become Indian citizens if the government allows. It is not automatic in nature. Right here, dash, right, requires notification by central government. Requires notification by central government. Okay. What does this mean? We attack Pakistan. If we don't issue a notification, Pakistani people will not be Indian citizens. Then what happens to them? The moment we acquire that territory, that becomes Indian territory. Then who are these Pakistani people? Stateless. Because they are not, there's nothing called Pakistan. They are not Indian citizens, so they become stateless. Okay. That's a thing that this requires what? Notification by central government. It is not automatic in nature. Now, enough of all this nonsense. Come to loss. How can we lose Indian citizenship? There are three ways. By renunciation. You give up. Give up. That I don't want Indian citizenship anymore. Enough. Or by termination. This happens automatically the moment you take some other country's citizenship. Obtaining citizenship of another country. Obtaining citizenship of another country. So your Indian citizenship is terminated automatically. Are you clear? A small point to add here. Let's say today China attacks India and China says that if we win the war, we'll kill all Indian citizens. You immediately say, no, I am giving up Indian citizenship. I am not an Indian citizen. Or you say, China, I am joining you only. I am a Chinese citizen from tomorrow. That may not be allowed. During war, the government of India can say, no, you can't go anywhere, you die here only. So, not applicable during war. Okay. Parliament can make laws on conditions of citizenship. Under the Citizenship Act, Parliament has delegated this power. Where is that? This power to the government. Government, executive, Home Ministry. That is called delegated legislation. Yes or no? The law says that Parliament decides. Parliament said, yes, these are the criteria, and for this, if you want to make any change, Government of India, you can do it. Okay. So this provision is under this very law, allows the government to remove the criteria. Yes, they have, right? The CA 2019 petitions are pending in court. I will come to that point also. Next slide is that one. Done. Third one is deprivation. This is done by Government of India. By Government of India. This means we'll deprive you of your citizenship. But very interesting observation here. This is actually meant only for foreigners, meaning those who obtain citizenship by registration or naturalization. Right, applicable to those who obtained, citizenship via registration or naturalization. Applicable to those who obtained citizenship via registration or Naturalization. None? All okay? So, as an Indian citizen right now, all of us are by birth only. Any foreigner, any born in foreign land? Anyone who has come back to India? No one. Okay. We are all citizens by birth. There is no way or no law wherein the government can take away our citizenship. As of now, no law exists. Okay? This deprivation is meant only for foreigners. And these to depend on us. So right now, there is no law in the country which allows the central government to take away our citizenship. Are we clear? If you have obtained citizenship by fraud, if you have been outside country for 7 years or more without informing the consulate, 7 years, if you have been in jail in a foreign country for 2 years. So these are the various conditions. Here, you can be deprived. Done? Should we proceed now? So the point is that this is a very interesting law which is called what? See, citizenship was, or this act was amended multiple times, no problem there. But there was a 9th time this law was amended called CAA 2019. That caused lot of problems. So we will not discuss about the problems or the issues people had. The Shaheen Bagh protest, Shaheen Bagh protest? No? In Delhi, we had the Shaheen Bagh protest. So I'll explain, you will understand the protest. In 2015, the government of India issued a notification saying that all those people who have been facing persecution in our neighboring countries of Afghanistan, Pakistan and Bangladesh, belonging to certain minority communities there, if they come to India, right, till last year, 2015, last year is 2014, 31st December. If they come to India, we will not treat them as illegal migrants. The problem is, illegal migrants, people who come to India without valid documents, or they come with documents, but it expires. Clear? Illegal migrants are not allowed to apply for citizenship. Only legal migrants can. So if you're an illegal migrant, the government has only two options. Jail you first, find out which country you have come from, dump you there, or send you back there. Okay. These people who came from Afghanistan, Pakistan, Bangladesh, belonging to 6 minority communities: Hindus, Sikh, Buddhist, Jain, Parsi or Christian community. These people will not be called illegal migrants, even if they are. The moment you are not called illegal migrant, you become what? Legal migrant. If you are a legal migrant, you are allowed to apply for citizenship. This became a law in 2019 finally. The law said that the illegal migrants who came into India from Afghanistan, Bangladesh or Pakistan before that date, 2014, belonging to these 6 religions, will not be treated as illegal migrants. This means what? Now they are allowed to apply for citizenship. Okay? And not just that. So these are all people who are foreigners. They have no association to India or Indian citizen. This means they will all apply under which category? You are a foreigner. No association to Indian citizen. Naturalization. But there is a problem under naturalization. 12 years stay. 11 plus 1. For these categories, the 11-year time period has also been reduced to 5 years. The number of years of residency has been relaxed to 11 to 5. So for these people, what's the total time to stay? 6 years. 5 plus 1. Last 1 year continuously plus 5. So total 5 plus 1. Is this point clear? So, very important to understand, this law is not giving anybody citizenship. It is just making some people eligible for citizenship. There's a difference. Giving you citizenship or helping you apply for it. This only helps you apply for it because it removes the tag of illegal migration. Are you clear? So if you have come from say, Afghanistan and you have come to Delhi, great, you can apply for it. You come running to UP, no problem, apply for it. You come, keep running more, go to Bihar, no problem. Bengal, no problem. If you keep running further, now there's a problem. Who asked you to run so much? If you end up in a scheduled 6 area and are an illegal migrant, even though you belong to these committees, you still will have no benefit of this act. This act has exceptions. Number 1, Schedule 6 area. Does not apply. What does it mean? If you are somebody who is living in a Schedule 6 area in Assam, you came from Pakistan, you came in 2012, you are a Christian, will you be able to get the benefit of CAA 2019? Yes or no? No benefit. Sadly, you are still an illegal migrant. Are you clear? Also, number 2, if you stay in states which are under inner line permit. Are you aware of this point? There are certain states in our country where you can't randomly enter. If you want to today go to Andhra Pradesh, you can just take a bus, car, walk, bicycle, whatever. You need some document, special permission, not required. But if you want to go to Arunachal Pradesh, if you want to go to Nagaland, if you want to go to Mizoram, if you want to go to Manipur, in these states, you need special permission. Very easy to obtain, that's not my point, but it is required. These states are called inner line permit states. So, 4 states, Arunachal, Nagaland, Mizoram, Manipur. Now, in these states, if you want to enter, you need to apply. They have their official website. You can apply for a domestic tourist. The fees is just 300 rupees, at least for Nagaland. If they have changed recently, I am not sure. And you can get a 15 or 30 day permission to go roam around, throw garbage there, destroy that area also, like how we have destroyed the city, spoil that completely, and then come back. So, these are called inner line permit areas. So, if you are a Bangladeshi Hindu living in Nagaland as an illegal migrant, you will not get the benefit of CAA 2019. You are still an illegal migrant. Who asked you to go there? You have committed double crime. Firstly, coming to India illegally, entering these areas illegally. So, we do this for the protection of tribals. People having a distinct way of life, because this is not a new concept. Just to clarify, this concept has come from British times. Since 1873, there is a regulation called Bengal East Frontier Regulation, where outsiders' entry was controlled in these areas. Are you clear? We have just extended that benefit. We have recent demands from Mizoram people also, Meghalaya people also, for inner line permit, because it creates a check. Otherwise, outsiders, especially today's day and age, these people called vloggers, they reach everywhere. And then they make videos from all the hawkers asking them what have you put in the food. So, vloggers are a new dangerous breed of people going everywhere, social media influencers. The country needs to be saved from them. So, what if outsiders go here, disturb the local people, the population, etc. So, to prevent free movement, to safeguard the indigenous tribals and their way of life, we have this provision. Are you clear? That's CAA 2019. So, because the CAA 2019 did not include Muslims, that is why Muslims were protesting in Shaheen Bagh in Delhi. Though this makes no sense. This law is not taking away anybody's citizenship actually. This law is not meant for Indians also. This law is meant for foreigners. Yes or no? This law is not affecting us as Indian citizens because this law is meant for illegal migrants. But because of certain issues which are best left for mains discussion, because government had different plan to have NRC and PR and all, they had some concerns. Anyway, so this was a CAA 2019. Are you clear? Doubt, dispute? No? If you have no doubt, dispute, then you know. Let's go to part 20, article 368, amendment to the Constitution. Very simple, very easy to understand. Amendment to the Indian Constitution. Read the process. Parliament may, in the exercise of its constituent power, amend by way of what? Underline, addition, variation or repeal. What is addition? You add things. What is variation? You subtract things. What is repeal? Remove completely any provision of this constitution in accordance with the procedure. So what is the procedure? Where is the procedure? Here is the procedure. Other conditions. Come to other conditions first. Are you all there? If you want to bring such a bill, such bills can be initiated in either house of parliament. Lok Sabha or not in the states. Not SL. Only center. Number 2. This bill can be brought by any MP. So we have two types of MPs. Not good and bad. Ministers and non-ministers. Who are non-ministers? They are called private members. This bill can be introduced by minister or by a private member. Private member means a non-minister. Just a small question. Can a private member be from BJP? Is it possible? Yes or no? Yes, of course. BJP has 240 MPs. Not all are ministers. Very few are ministers. Remaining MPs are private members. Okay? Okay. So sometimes like Article 3 kind of bill requires prior permission of President. This bill does not. And very important. No possibility of joint sitting. Both houses must pass this bill separately. Okay? And when the bill is sent to the President, you know very well, President has to sign this bill. No veto power. The President must give his assent to the bill. He can either withhold his assent nor return the bill. Nothing allowed. Indira Gandhi, through the 24th Amendment Act of the year 1971, made it mandatory that the President has to give assent to constitutional amendment bills. Are we clear? You cannot sit and do a pocket veto nonsense. If you have to vote smart, then you know Article 61. No. Impeachment. We can impeach you. That is why they will sign it immediately. Clear on this? Everyone? Okay. Now let's not forget the majority required. This is the condition. What's the majority? Special majority. And that's a we come to this now. And the combination. So you have 2/3 members present and voting, and also more than 50% of total membership or total strength of the house. Combination majority is required. Okay. One more small point. If the amendment bill tries to modify the federal features, let's say the amendment bill tries to take away state power. The problem is that such bills can be brought only by center. States cannot. So what if the center tries to reduce the state's power? That could be a problem. Let's say 7th schedule. Center says we'll take all the topics from state list and move to union list. That could be a problem. So for that we also need state's consent. So in that case, when a constitutional amendment bill tries to change the federal structure, it needs to be ratified, passed, approved by states as well. Meaning you follow the same majority, 2/3 members present in voting, plus more than 50% total strength in the parliament, and not less than 50% of the state legislature. So once this process is done, you send the bill to all the states. Okay? The moment half of the states say yes, the bill is passed. And the states have to say yes with what majority? Simple. Simple meaning more than 50% present and voting. Are you clear? If half states say yes, task is done. Clear? Other half say no. What happens? We don't care. Half say yes, task is done. In how much time? No time limit. How many states do we have? 28. If 13 states say yes and the 14th state says yes after 40 years, what happens? The bill is passed after 40 years. No time limit. Why I'm saying this is in some other country like USA, there is a time limit, 7-year time limit. If the states there, and there it's not half, it's 3/4 states. If the states don't approve within 7 years, the bill lapses. Bill is dead. India, there is no such problem. Are you clear? But now is the bigger question. What topics are actually examples of federal provision? This is the only list. It is not an illustrative list. It's an exhaustive list. Complete. So, election of president and the manner. Because election of president also requires MLAs. Yes or no? MLAs are part of the electoral college. If tomorrow the center says remove the MLAs, nonsense. You can with this process. Clear? This is required. Their consent is required. Or extent of the executive power of center or state. Or Supreme Court and High Court. Or distribution of legislative power between union and state. Or any of the lists in the 7 schedules. See, I mentioned it. If you want to modify union list, state list, concurrent list, whatever, you need state permission also. Or if you want to modify representation of states in the parliament. Or if you want to change this procedure only. It is too complicated, I want to have a simple procedure. For that also you need the same procedure. Are we clear? Please remember this list. This is important. Now, before we move on, just a small point. There are certain other places where the same majority is required. It is not a part of amendment. So, this is not under Article 368. But the majority required is the same. That is 2/3 present and voting, more than 50% total strength or total membership. Okay? Removal of all these people requires the same special majority. Clear? Number 2, approval of national emergency requires this majority only. Number 3, to create a council. You will understand these two when I discuss them later on. Okay? So don't worry on that. Just remember that this kind of majority is required for some other things also, which we'll come to as and when the time is there. Done? Will you proceed? Article 368, Part 20. Okay. I have just given this basic structure doctrine here. Basic information. Basic structure concept. When was it launched? This is an innovation by who? Supreme Court, of course. In the Keswanand Bharti 1973, the priest Keswanand Bharti ji from Edneer Mutt in Kerala died recently, few years back. So Keswanand Bharti case, this is an innovation by Supreme Court. Innovation, not mentioned in the Constitution. Not mentioned, not defined. Not mentioned in Constitution. No definition. Supreme Court has said that we will keep on giving you examples without any definition. And it was the largest ever bench so far. 13 judge bench. And what was the judgment? 7:6. Such clear majority. Yes or no? How can we rely on this judgment? Judgment means 10:3, 11:2. It inspires confidence. If one judge has changed his opinion, we will not be studying this topic only. Less topics for you to study. And at that point of time, there was a convention that senior most Supreme Court judge becomes the Chief Justice. Now it is a practice. Now it is actually a Supreme Court judgment. At that time, there was a convention on practice. This judgment was against Indira Gandhi because she wanted to make changes, but it did not allow the changes. 3 of the senior most judges, Justice Hegde, Grover, and Justice Shelat, they were part of the 7 group. Now, Indira Gandhi, the time came for the retirement of the judge, Chief Justice. Indira Gandhi bypassed all those 3 and made her favorite, A.N. Ray, who was a part of this minority, as the Chief Justice of India. That was the first instance where a junior judge was made the Chief Justice since independence. First instance. All 3 judges resigned immediately. Then came one more instance in 1977. Again, because of her judgment, Justice H.R. Khanna, who was the next in line to be the Chief Justice, was not made the Chief Justice. A junior judge, M.H. Beg, was made the Chief Justice. Again by Indira Gandhi. This concept of senior-most judge being CJI has been broken only 2 times. Both by Indira Gandhi. Because she did not like the judgment. And people are calling current government as dictatorial. Current government can be called useless, not dictatorial. Sadly. That is a wrong connotation. Right? Why I am saying this is because this is called fascism. When you talk about imposing the strict regulations and enforcing laws, modifying them to suit your purposes, Indira Gandhi was at the top. Others are here. Okay? She was the best at this. Anyway, these are elements of basic structure that the Supreme Court has given that they feel are essential parts. You can't modify them. I hope you are aware. Basic structure cannot be amended. The best part of it is judicial review. This phrase, judicial review, it is not mentioned anywhere in the Constitution. Please go and search. Don't search. It is not mentioned. Have faith in me. But my point is, Supreme Court has called it part of basic structure now. This means if you make any law which says this is beyond judicial review, court says no. Nothing is beyond judicial review. We'll check everything. So there is a very famous case called Minerva Mills case, where Supreme Court said that judicial review is a part of basic structure. So something that is not mentioned has been made a part of basic structure. 13 clause 2. Article 13 clause 2. Article 32. Article 142 and 226. These articles have a similar concept of review by judiciary. But my point is it directly mentioned here? No. But in the implied sense, it exists. There are 2 things, implied sense and explicitly mentioned. Clearly mentioned. Clearly not mentioned. In the implied sense, it exists. If you make any kind of law which takes away fundamental rights, that law is declared void. 13 clause. It does not mention judicial review directly, but the court can check it. Very good question. We'll come to that. Okay. Are we all clear here? All done? Any doubt? No doubt? UPSC has some doubt. Sorry. '71st Amendment Act. 3 things were added. Konkani, Manipuri and Nepali. 1, 2 and 3. Right answer is A. Okay, great. All okay here? One and two only. Consider the following subjects under the Constitution of India. So it says that which of these states require ratification by legislature? States. So lists, extent of executive power, governor's office, not mentioned. So 1 and 2 only. Okay, very good. Keep solving. B. Others? Are we there? A bill amending the Constitution requires prior recommendation of President. Yes or no? No such condition. Remove one. One is removed. Elimination technique. On YouTube, they'll make a video of this. Learn elimination technique in 5 minutes. The problem, it's a good thing. The problem is you have to know facts for that. For every elimination, you have to know facts. That's the big challenge. Okay, one more question, please. How many say B? B for Bombay. D. Oh, okay. Then what's the point? An amendment to the Constitution of India can be initiated by introduction of the bill in the Lok Sabha only. Any house. If such an amendment seeks to make changes in the federal character, the amendment also requires to be ratified by not all, half of the states. That was a problem. But nobody fell prey to this. Disappointing. So, okay, all of you got this correct. D. Okay, solve this. Read carefully all the options. Now, relax. All the options. Read them first. The preamble to the Constitution of India is a part of the Constitution but has no legal effect. Is it correct? It is correct actually. It is a part. It has no legal effect. This point is actually correct. But we should also give chance to other options. Not a part of the Constitution. This is wrong. It is a part of the Constitution. A part, okay, and has same legal effect as other part. That is wrong. A part but has no legal effect independently of other parts. Now this is actually a better statement than this one. On its own, preamble can't be claimed in court. It must be read with other parts. That is why this is not wrong, but this is a more accurate statement. Hence D. So when you read the question, read A and mark A no. Read all four options. Liberty. Okay, okay. How many say A? How many say B? How many say C? How many say D? Okay, great. So we have all choosing at least B, C, or D. So firstly, A is wrong. It says which of the following is the best safeguard of liberty. What is the meaning of committed judiciary? Committed judiciary in public administration is a negative concept. It means judiciary committed to upholding executive policies. Whatever laws government makes or whatever action government takes, judiciary will always support that. But what if the action is against people's liberty then? Judiciary will still support it. That's the problem. So committed judiciary means judiciary committed towards the government, not towards people. So it is a negative concept. Centralization of power, how can that be for liberty? It is against liberty. When power is centralized, it is concentrated. This means we have concentration of power in the hands of a certain group which can then do whatever they want. So centralization of power is never nice because it causes concentration which can then be detrimental to liberty. Elected government. Yes, like we have liberty in China, Pakistan. I hope you get the point now. Elected government is no guarantee of liberty. Elected government is just the most basic form of democracy. That's why it is called minimal democracy. We have to have liberal democracy, free and fair elections. Bangladesh had elections recently, right? Mamata Banerjee, Didi, she said that elections in Bangladesh were very peaceful because the major party was banned from contesting elections. Of course, it will be peaceful. If she feels that that was a great election, let us have elections in West Bengal by banning TMC. Peaceful. Elections have to be fair. Mere election not sufficient. So elected government is not sufficient condition. What is the best way is to keep a check on all the organs. No organ crosses its boundaries. Checks and balances means what? Separation of powers. Are we clear? So separation of powers. The confusion was between these two only. Separation of powers is correct. Okay. Quickly. Okay. Liberty, most appropriate definition. Now don't say that, sir, I accept the first one only as most appropriate. No. What is correct? So the option was between B and D, but absence of restraint is a negative concept, very limited. We don't use this. We choose this. Opportunity to develop oneself fully. Freedom to. Freedom from. Freedom to. We choose freedom to. In 1950, so which three words were added later on? Socialist, secular and integrity. So remove this, remove this, remove this. These three were there since the beginning. B is the right answer. Sovereign democratic republic. D. Article 360, which part? Addition, variation, repeal. Sir, the question. Answer. D for Delhi, B for Bombay. Delhi. Okay. The Constitution of India defines. Firstly, it is not mentioned in the Constitution, and there is no definition. Double wrong. Okay. Second one, the Constitution of India provides for judicial review. Now, let me be very clear on this. Some of you might have a problem. That's sir, it's not mentioned. Mentions. It says provides for. Provides for could be implied also. So the wording, I agree, is not good. That is wrong. But we take the most basic idea that does the Constitution directly mention it? No. End of story. But yes, if somebody has a confusion that this word provides for is not very clear, I would agree with you also. But that's UPSC. What to do? They have full 1 year to prepare questions. Still they prepare these kind of statements. Okay. Salary should be deducted from there. Okay. D. Neither 1 nor 2. Let's come to part 3. Part 3. Fundamental rights. Okay. First up, classification of rights. We have various rights. Right to kill. Right to breathe. No, not right to kill, sorry. Right to breathe, etc. But rights have to be given recognition by laws. Then only are they offered protection. So we call those kind of rights as legal rights. Or I can use a more stylish term, statutory rights. You know statutory or statute? What is statute? Statute simply means law. Synonym, statute, law. You want to impress people? Statute. Confuse them. What the hell is this guy talking about? Or law. Legal right. Example. There is a law in the country called RPA 1951. I hope you are aware. Representation of People's Act. Under RPA 51, there is a section 62 which says that every citizen has a right to vote. Statutory right. Okay. There is one more law called Industrial Disputes Act. Under that law, they define the word strike. What is called going on strike? Industrial Disputes Act. Right to strike. All these are examples of what? Legal rights. Okay. Is the Constitution a law? Yes or no? My question is the Constitution a law? Of course it's a law. The most fundamental law of the land. Yes or no? So, let's say this is the Constitution. Every right mentioned here, will that be called a legal right? Yes, of course, it's called a legal right. But a better word for it would be constitutional right. For example, there is an article called Article 300 capital A, which is called right to property. Now, rights mentioned here are called constitutional rights. Again, my question is, right to property is a legal right, yes or no? Yes. It's a constitutional right, yes or no? A better word is saying constitution. Like you are an Indian citizen, yes or no? You are also somebody who belongs to your state, Andhra Pradesh or Telangana, whatever. Same thing. But inside the Constitution, there is a specific part, which is called Part 3. All the rights mentioned in Part 3, let's say Article 21, right to life. Is right to life a legal right? Yes, legal right. Is it a constitutional right? Yes, it's a constitutional right. it is inside a constitution. But a more accurate word would be calling it a fundamental right. So these are actually FRs. So please don't be confused. The diagram is somewhat like this. Legal right. Inside that you have CR. Inside that you have FR. Okay. So if you get a term like right to property is a legal right, don't go crazy that no, it is a constitutional right only. Cancel that statement. Selection gets cancelled then. Okay. Will you proceed? Now the problem with this fundamental rights is that these rights are offering protection against whom? The state and other people also. State. For that we have to know what is a state. Is Abhiram IAS a state? No. Why? Entity. Is SBI a state? Not a state. State. Why? How do you decide this? No? Funds. Okay. What funds? How much percentage? No, there's confusions happening, right? Depending on what percentage, how to decide this. Article 12 actually defines what is a state. Some things are clear. Parliament is a state. Yes. State legislature, Government of India, Government of State, local bodies. Very good. And then the article uses a very vague kind of statement, other authorities. Okay. In 1981, a Supreme Court judgment defined what is meant by other. This actually is not mentioned in Article 12. This is actually a Supreme Court judgment which is called Ajay Hasia, 1981. Okay. So the Supreme Court said that anybody which is created by an act of legislature, okay, or executive order is a part of state. CBI, part of state. Okay. National Commission for Women, part of state. Lokpal, part of state. Okay. Second, if the body is substantially controlled by the government or finance, now the court has not declared how much, 10%, 90%, 51%, that's not mentioned. Because the court says what is meant by substantially financed. The body depends on the government for its day-to-day operation. It could be 10% or 80%. Meaning if the government stops the funding, the body might not survive. That is called substantial finance. Are you clear? So the percentage is not different. That can depend on case to case basis. Third, it performs public and sovereign functions like intelligence bodies. Okay, NIA, RAW, police. They perform sovereign functions. You can write example here. IB, RAW, police. They perform sovereign functions. And the fourth one, it enjoys government monopoly. Government monopoly. A monopoly given by the government. Okay. For example, IRCTC. Let's say today the government issues an order saying that all coaching institutes have to shut down. Only Abhiram IAS will survive. The only UPSC institute. Then Abhiram IAS becomes what? State. Because this monopoly has been given by the government. Clear? But if Abhiram IAS performs very well because of amazing teachers like you, because of amazing students like you, if it performs very well and other institutes shut down on their own because of lack of competition, this is a self-created monopoly. Then Abhiram IAS is not a part of it. Difference is important. Self-created monopoly versus state-bestowed monopoly. We are focusing only on state-bestowed monopoly. Okay. For example, there is a very important body in our country called Board for Control of Cricket in India, BCCI. Is it a part of state? BCCI is a Tamil Nadu based cooperative society. Now you might claim, but so it has complete monopoly over cricket. Yes, it has. Self-created monopoly. Today, you can also start your own cricket league. Make a phone call to Virat Kohli and Bumrah. If they join you, great. So BCCI is not a part of state. It is a self-created monopoly. Are we clear? So, and BCCI is just a Tamil Nadu based cooperative society. So, on Sunday, India did not lose the match. Tamil Nadu based cooperative society lost the match. So when they lose, we'll feel good feeling like this only. When we win, India wins. Okay, and when we lose, Tamil Nadu based cooperative society lost. No concern. Immediately disown them. Okay. One more thing which is important for us to know. All these bodies are mentioned. One body is not mentioned. Very important body. Which one? No, it is. Body is created by statute. Constitutional statute mentioned. Sirs and ma'ams, there are 3 organs. Where is that? Is it mentioned? Is it a part of state? Supreme Court has said that we are not a part of state. For their judicial functions. They are very smart. They say we are outside this. Put a star mark below and write. For its judicial functions, comma, for their, not its, grammatical error. For their judicial functions, sorry to spoil your notes. For their judicial functions, comma, constitutional courts are, for their judicial functions, comma, constitutional courts are not covered under Article 12. Are not covered under Article 12. What is this constitutional court? Supreme Court. And both are called constitutional court. Why? Because they have the power to interpret the Constitution. So lower courts are not called constitutional courts. Okay. This is a Supreme Court judgment. Rupa Hurra 2002. I am not creating this on my own. Court is saying all this nonsense, all these nice things. Anyway, let's move on. Enough of Article 12. Should we proceed? Great. Article 13. Simple provisions. Number 1. All the laws in the country which existed before the Constitution, they can continue. No problem. But if any of their provision violates fundamental rights, those provisions are automatically cancelled. I'll repeat. Any law which was there before the commencement of this Constitution, those laws can continue. But if in those laws there is any provision which violates any fundamental right, that, not the entire law, that provision is cancelled. So, laws cannot violate fundamental rights. Are we clear? Second clause. The state cannot make any law which takes away or abridges, meaning lessens, reduces the fundamental rights of people. And when I say law, what does law mean? Law means ordinance, order, bylaw, rule, regulation, notification, custom. If you follow any custom in the country which violates your fundamental rights, that custom is cancelled. Automatically void. Okay? The beauty of this is, this word is not mentioned here. Yes or no? Amendment. Is amendment a law? No. Amendment is not a law. Amendment is amendment. That is how the basic structure concept is. Okay? So please be very clear. You can't make a law to take away fundamental rights, but you can amend to take away fundamental rights. Difference. Laws can't be made. Amendments can be made. Law requires simple majority. Amendment requires special majority. Different. Okay. Now let's jump on to our fundamental rights. You know very well 6 types of rights, all that nonsense we can see here mentioned there. Right to equality, freedom, exploitation. Not right to, sorry, right against. Right against exploitation. Right to exploitation only with the parents and government. Okay. So right to freedom of religion, dangerous rights, then culture and education rights, and right to constitutional remedies. We'll come to this later on. Let's start. Article 14, equality before law and equal protection of laws. 2 phrases, simple meaning. First one, equal protection of, equality before law. This is a concept borrowed from UK. What does it mean? This is the basic concept of equality that we understand. What it means is everybody is equal in the eyes of law. It is a part of rule of law. What is rule of law? Lex rex. No? In the good old days, we had the concept called rex lex. So what is meant by rex lex? Yes, very good. King is law. Whatever the king says is the law. Good or bad, however crazy it is. But then we said, no, this is nonsense. Law is king. Law is king. This is right. This is, oh sorry. This is wrong. This is right. Are you clear? This is the meaning of rule of law. Who is ruling the country? People. No, laws are ruling the country. If you acquire the post of a prime minister, your task is to enforce laws only. That's the meaning. So, no person is above the law except rich people. Sorry. No person is above the law. Law applies equally to all, regardless of your status, your position, etc. Okay. You know, this is a joke only, but still. So, absence of special privilege. Equality before law. But I hope you understand, this is India, not USA. Here, rights have restrictions. Fundamental rights in India are not absolute in nature. Don't go crazy. It has restrictions. So, we can impose restrictions on the use of fundamental rights. Look at the exception here. Okay, this article, can you please tell me what the hell is it? 361. President and governors. Very good. Immunity given to the governors and president. I hope you are aware that presidents can't be arrested. They can't be jailed. If we murder somebody, jail immediately. If the president kills somebody, no jail. Firstly impeachment, then jail. Step by step. So, special privilege. Or parliamentary privilege. In the House, MPs can speak any nonsense. No questions raised. You can't file a court case against them for whatever they say in the parliament. That is why smart politicians make stupid remarks in the House. Didi recently was shouting in the assembly, something like Modi chor or something. I don't know what she was saying. You can't file a case against her of defamation because in the parliament, in the assembly, privilege. Innocent Rahul Gandhi, he makes these statements outside the parliament. And that's why defamation case is filed against him. That's why now he has started saying these things inside the parliament. Somebody told him that, sir, enough cases are there against you, please. Go to parliament and say all these things. Okay, that's why he puts his hand in the pocket and roams around here and there, making random statements. So please make statements inside the parliament, not outside. Outside defamation case. Then what is diplomatic immunity? Diplomats of other countries get immunity. This means that if a diplomat from a foreign country comes to India, commits a crime, you can't punish them. You will send them back to the parent country. That country will punish them. Same for us also. If you clear the exam, become IFS officer, you go to a foreign country, you commit a crime, will you be punished there? No, they'll send you back to India. He will punish you. You can try this in future. You'll get to know. Okay. If you have no faith, what can you do? You can try this. But the problem with equality before law is that if we treat unequal people as equal, it makes no sense. Somebody has an income of 1 lakh rupees per year. Somebody has income of 1 lakh rupees per month. We impose same income tax on both of them. Is it fair? It is equality, but this is stupid. How can you do this to these people? Yes or no? So the problem here is we should treat only people in a similar circumstance as equal. Okay? For example, no, this is negative income. Yes. No one is above you. Okay? So it negates the point. Negative. This is a positive discrimination. Now, if somebody earns 1.1 lakh per month, can we club them together? What do you see? Similar circumstance. We can't have exact circumstance. People in similar circumstance should be treated in the same fashion. Are you clear? So that is called equal protection of law. This is something inspired from USA. USA has a 14th amendment which mentions the same thing. Like should be treated alike. People in similar circumstances should be treated in the same fashion, like reservation. We have reservation policy extended to SCs, STs, SCBC. SCBC meaning socially and educationally backward classes. Why? It violates equality, positive discrimination. Are you clear? Because they might not have the same circumstance. That is why progressive taxation, with the increase in income, tax rate increases. So equal protection of laws. Clear? Now what is rule of law? Rule of law simply means no man is punishable except for breach of law. That law is supreme and equality before law. That is why we call article, in fact not just article 14, this entire group of right to equality, it is referred to as civil rights. What is meant by civil right? Right against discrimination. Non-discrimination means civil rights. Like in USA, blacks were facing discrimination. In 1964, they had the civil rights movement in USA. So civil rights means right against discrimination. Are you clear? Okay. So these two are there in India. This is not in India. In UK, they say that rights are not given by the Constitution. In India, we say no. Rights are given by the Constitution. So rule of law has 3 elements given by Albert Venn Dicey. Okay, A.V. Dicey. First 2 are applicable in India, third one is it. Clear? Article 14, 2 parts. So I'll give you a very simple idea about Article 14. Article 14 places limitation on state. So if you are confused what the hell is rule of law, remember it simply means limitation on state. State cannot have arbitrary power. Okay? The moment a law is made or an action is taken which gives government random kind of power, unchecked power, unfettered power, unrestricted power, what article gets violated? 14. Always remember, if anybody is being given unchecked power, Article 14 gets violated. Are we clear? Everyone? Okay, great. Then let's move on to Article 15 quickly. Article 15 is meant only for citizens. There are 5 rights meant only for citizens. 15, 16, 19, 29 and 30. These 5 fundamental rights are meant only for citizens. 15, 16, 19, 29, 30. Okay. The state shall not discriminate against any citizen on grounds only of. Other grounds possible. These grounds not possible. 5 grounds. RRCSP. Religion, race, caste, sex, place of birth. Religion, race, caste, sex, place of birth. On these grounds, you cannot discriminate. State will not discriminate against any citizen. On other grounds, it can. Like age, no, voting age, 18, education qualification. If you are under 21, can't sit for UPSC. If you are not a graduate, can't sit for UPSC. Right? What else? Okay. Economic status, discrimination possible. Clear? A small problem. I mean, government college for girls. State can't discriminate against citizens based on sex, gender. What nonsense is this? Protest tomorrow. This is the third clause of Article 15. Please read. Before you jump on to the protest, read. Nothing in this article shall prevent the state from making any special provision for women and children. Okay, so girls' college, etc. Please don't be angry. Article allows it. Okay. This article clause says that state will not discriminate. Can other people discriminate? No. Clause 2 says no. If you are, please don't do it. Okay. Very clear. No citizen shall face any kind of discrimination on the grounds of RRCSP. Be it from entering shops, public restaurants, etc., using wells, tanks. See, any place which is open for public in general, you cannot discriminate against citizens on the grounds of RRCSP. Are we clear? Okay. Yes, if it is open to public. For example, let's say a club, a pub, a restaurant. It is open to public, you can't. In your house, you can. But, difference. I'll give you a simple example. Somebody lets out their flat on rent, gives an official ad in the newspaper. The moment you give an ad in the newspaper, it is open to public. Somebody comes to your house as a renter. He says, I want your flat. You ask them, are you a non-vegetarian? He says, yes, 3 times a day. You say, no, get lost from here, leave. Is it violation of Article 15? Yes or no? No, it is not. Food habit. Article 15 happens only on the grounds of RRCSP. Other grounds possible. If the person comes and he wants a flat, you say, what is your religion? He says, Hindu, Christian, Jain, whatever. Get lost. Is it violating Article 15? Yes. Clear? But the onus to prove discrimination is on you, not on the person discriminating. For example, people cannot discriminate against you based on sex, gender. We have PG for girls only. Yes or no? Protest. You want a room there? One room, I also want. Now the problem there is, if you file a court case like this, the PG owner can simply say, I am not discriminating based on gender, based on morality, based on security. The onus to prove that you are facing discrimination based on gender is on you, not on the other person. Okay, so don't file these kind of cases. Court will scold you only. Are you clear? This is the point. And remember, it's only RRCSP. Other grounds it is allowed. Are we clear? Don't become emotional. To give you a simple example, this is a true incident also. There was a place, Y to name the city and defame the city. There was a food joint, some pizza or burger joint. The kids who were begging on the street, they wanted to enter and eat pizza or burger, okay, to spoil their health. They collected money and they wanted to enter the joint. The owner prevented them entry in the joint, denied them entry into public restaurant. Does it violate Article 15? What ground? What is yes? Ground. I want ground. Others. Does this denial violate Article 15? No, it does not. Okay. If you can prove that denial is based on RRCSP, okay. You can simply claim dress code, hygiene, whatever. That you can face discrimination. Are you clear? Other factors allowed. That's my point. Other factors allowed. RRCSP not. Okay. This is Article 15. Done. But then we had some changes made in Article 15, which was the provision for reservation in education. This was Article 15 originally, but then just below this only write reservation in education. So First Amendment Act 1951. What is this? 15 clause 4. Special provision for SCs, ST and SEBC. What is SEBC? Socially and educationally backward classes, not castes. Okay. E stands for educationally and C stands for classes. Okay. Initially, there was actually a communal government order in Madras, which was called Communal Government Order, based on which in Madras province, pre-independence, in Madras province, there was reservation based on caste and religion in government colleges. There was a lady called Champakam Dorairajan. She cleared the medical entrance exam, but because she was from the Brahmin community and only 2 seats were meant for Brahmins, the seats were occupied. She complained that how can I face discrimination based on religion in an education institution which is state funded or state maintained because of Article 29. The court said yes, and the court cancelled the policy of Madras government for reservation. To bypass that judgment only, this Amendment Act was passed. That no, we can make special provision for SC, ST and SEBC or OBC. Clear? Then one more Amendment Act. This was the 93rd one. It extended the provision how? It said that special provision for SC, ST, SEBC in private institutions also, with only one exception, MEI. MEI, Minority Educational Institution. Okay, so government can, state can make reservation in private schools and colleges also. It does not is their choice. It can. Okay. And below that write one more, which you all are aware of, 103rd Amendment Act 2019. Write the last point there. Done? Please write. Up to 10% reservation for EWS. Up to 10% reservation for EWS. Okay. So, the reservation in education was not there since the beginning of the Constitution. It is all through amendments. Okay. Clear? Let's end our discussion here only. We'll continue the further torture tomorrow. Bring these notes and we'll get the next ones tomorrow. Okay. That's all for me. Jai Hind.